Good afternoon, all. It's March 7th. Thrilled to be back with you and hoping that everyone is well. I'll walk through the agenda because what we have is a packed program and I want to give you a sense of what's ahead. I'll be speaking for just a moment or two more, and then Jared Joyce will be with us out of Syracuse to tell us about the New York Housing Compact and its relationship to the OCHIP program. Seth Gilbertson, familiar to all of you, will be back on the program to discuss salary transparency amendments. Tongue twister there for a moment. Devin Karras, also back on the program, will be looking at employee benefits and the ties to the end of the public health emergency. Ksenia Primo is on as well, and will follow Devin with an eye on immigration issues to keep in mind when contemplating layoffs and reduction in force. And thereafter, Peter Robb, also new to the program, will discuss how employers should be approaching severance packages. But before we get to any of that, allow me just to set the stage a bit. So next slide, please, Kathy, and I can just remind you all where we are. It is 3 years since we all learned of the first COVID in New York State. It wasn't called COVID at that point. And a lot has changed. There have been many whom we've lost, many who sacrificed, many whose bravery we look back on still with awe. And this program got its start back then. And it's 3 years later, we continue to have an obligation to all of you to give you information that is timely, complete, and otherwise that helps you advance the work that you do in your businesses and otherwise at your workplaces. And so please know that commitment remains. And while we're grateful very much that we are seeing some daylight with the virus and its effects 3 years in the rear view, we still know there's more recovery to come and more information that we look forward to sharing with you as this program continues. So with that, let me bring on Jared. I will keep my comments there for today. And Jared is going to be focusing on state and local approaches to solving housing shortages, as I alluded to a moment ago. A bit on Jared, just because he's new to all of you. He comes to us again from the Syracuse office and attended Syracuse Law and also was a summer law clerk while at the law school. And we're just really delighted to have Jared on to the program. And Jared, the floor is yours. Looking forward to learning about housing and what's going on in Syracuse in relation to some of the governor's big plans.
All right, thank you. And thanks everybody for joining us today. If we go to the next slide, please, we'll get started.
And Jared, we're having just a little trouble hearing you. If you wouldn't mind, thank you. That's great.
I'll try and sit in a little closer. Sorry. So quickly, we're going to talk about how we've gotten ourselves into the situation where we're facing a housing crisis. And we're going to look at the New York Housing Compact and the Onondaga County Housing Initiative program known as OCHIP. Next slide, please. So how did we get here? There are fewer new homes that are being built. Fewer new homes were built in the 10 years that ended in 2018 than in any decade since the 1960s. There's a shortage of housing units for sale or rent. As of 2019, there was an estimated shortage of housing units for sale or rent of 3.8 million units nationwide. And also, where everybody's here, COVID-19, the pandemic induced materials and labor shortages that have exacerbated these trends, which is evidenced by a spike in home prices that we've all seen during the pandemic. And
so Jared, I apologize. We're having some audio issues still. And so if you wouldn't mind adjusting, otherwise, we will bring on another presenter while you take care of that in the background. Let's just see if you have an opportunity to try once more, please.
Okay, is this any better?
That is much better.
Okay, I just got to sit in real close to my screen. I apologize.
Thank you very much.
So as I was saying, although housing interest rates have already helped reduce demand in the market, and any economic downturn can also trigger a drop in housing prices, although it might lessen the economic impacts on people, they're not going to address the underlying causes of the housing shortage. And any solution to that is going to require a localized approach. So we're going to look at Governor Hochul's proposed New York Housing Compact as well as OCHA. Next slide, please. So the New York Housing Compact is part of Governor Hochul's fiscal year 2024 executive budget, and it aims to resolve three major contributing factors to New York State's housing shortage, which are more jobs than housing. New York has created 1.2 million jobs over the past 10 years, but only 400,000 new homes. Skyrocketing rent and home prices. In the New York City metro area, rents have risen 30% since 2015, and home prices have risen 50%. Outside of New York City, rents have risen 40 to 60%, and home prices have risen 50 to 80%. It also aims to address barriers to housing growth, which include restrictive zoning laws, red tape, and lengthy approval processes that make building new homes more difficult. Next slide, please. So the New York Housing Compact aims to create 800,000 new housing units statewide over the next 10 years. Upstate municipalities are required to grow the number of housing units by 1% every 3 years. And New York City and down housing approval. So those municipalities that fail to meet their 3-year goals will be subjected to a state-run approval process for housing developments of 20 or more units. And developers whose plans are rejected may seek fast-track state approval, even if their plans are in violation of local zoning ordinance. Next slide, please. Other aspects of the New York Housing Compact: it aims to provide infrastructure and planning funding. It has a focus on transit-oriented development, and it aims to remove obstacles to housing approval, which not only applies to zoning, but also relief from certain environmental reviews. It provides incentives to build and rehabilitate housing. And in New York City, they are going to make specific changes to the housing density laws and laws restricting which commercial buildings are eligible for conversion to residential. Next slide, please. So the Onondaga County Housing Initiative Program, that is a $10 million housing fund that is available to both private sector and nonprofit developers. And I think something that is unique to that is it's available for any type of housing project, which includes affordable housing, market rate, apartments, condos, and single family homes. But it does give preference to projects that include affordable housing, adaptive reuse buildings, and brownfield development. It offers a $5,000 grant per unit for projects consisting of between 5 and 50 units. So that would mean a maximum award of $250,000 for 50 unit development. But there's also the possibility to increase the maximum award to $750,000 for projects that the county deems to be regionally significant, although the county did not provide any additional information as to what would be regionally significant. So that is the New York Housing Compact and OCHIP in a nutshell. Thank you.
Jared, well, thank you so much for taking the time to bring us all up to speed, and glad we could work through those audio issues. If anyone has a question for Jared, please enter it in the chat. And with that, let me bring on our next speaker, who is Seth Gilbertson. We're glad that Seth is back with us for a brief update on New York State amendments to salary transparency. Seth has covered this topic before on the program, and there's some new information for all of you. So Seth, the floor is yours. Welcome back, and glad to have the Buffalo office represented here.
Thanks, Gabe. Next slide, please. Just for, in case Rip Van Winkle's in the audience here today, for those of you who haven't heard about the New York State Salary Transparency Law, and I am referring specifically to the state law, not any of the more regional laws, including New York City, Albany, Ithaca, Westchester, that have gone into effect are about to go into effect within the last 12 months or so. So it applies to 4 or more employees. That's essentially everybody. Only temporary temp firms are exempt. The core of the law requirement is that there must be a disclosure of the range of compensation that the employer in good faith believes to be accurate at the time of the posting. And the Department of Labor can issue civil penalties for non-compliance. So that's the basic part of the law. Recently, just at the end of the last week, Governor Hochul signed some amendments to the law. The law, to be clear, has not gone into effect yet. It goes into effect on September 17th. And the amendments will take effect on that same date. So they don't change anything about that you have to do now. They just change what the law is going to be when it goes into effect. These were presumably negotiated between Governor Hochul and the Senate and the Assembly prior to her signing the law back in December. Next slide, please. A few of the highlights of the amendments will be probably the biggest one is to limit the geographic scope of the law, which under its original wording was extraordinarily broad and applied to any job that can or will be performed in New York State. So essentially everything unless you're working at a specific location in another state that would have essentially applied to all remote work, regardless of where it would have what was intended to have been performed. The amended version will say the job promotion transfer opportunity will physically be performed at least in part in New York State. So you need to have some physical presence here, or you need to report essentially to somebody who is a person or an office in New York. So still applies to remote work that's done in New York, but would not automatically apply to a remote worker being hired from New York in a foreign jurisdiction, let's say Pennsylvania or New Jersey or something like that, unless the supervisor of that individual was based in New York. Next slide, please. The prior law, the original wording of the law, used the term advertise, but did not define what that actually meant. Now we have a clear definition of that it is actually a written description of an employment opportunity, which more closely mirrors pay transparency laws from around the state, gives us a little bit clearer definition of what this is going to apply to. I still think, though, the formulation advertise is a bit odd. We would normally call this a job posting. Next slide, please. And the original law, the original wording of the law included a record keeping requirement that essentially appeared as though it would persist into perpetuity. That has been removed. We still believe that employers should maintain some records, particularly around how that good faith assessment of what the range of compensation would be. We'll probably be providing, I think it's safe to say, Bond will be providing some guidance as to what that retention period may be once we see the regulations and further guidance of this thing. Again, we have until September. At this point, I'd say probably keep what you have, any documentation internal regarding how you set the range of compensation, and we'll hope to provide some more clarity around that. We're kind of waiting to see the regulations before we jump into that fray. Next slide, please. So what can we do now? Again, goes into effect September 17th. Think about the reporting structure so you know who it does apply to, particularly if you are employing remote workers in other states. Are they reporting back to a supervisor or office in New York? If so, this is going to apply. Seriously consider performing an equity and compression analysis before you begin posting pay range. Once you start posting these things and people see what you're paying and become unhappy with that, they may file complaints. You want to know what they're going to find, particularly on the equity side. I think it's really important. Bond can help with that. Please reach out to your contact there if here at the firm if you need help with that. And that's it for me, kid. Thanks.
Seth, thank you. That was succinct and very much in the vein of catching us up. So we thank you for it. There are a couple of questions that are in the chat. So if you wouldn't mind addressing those, we'd appreciate it. And let me bring on our next speaker, knowing that we have a lot to cover today. Now we have Devin Karras back on the program. Devin was with us during December of last year, and now we'll be addressing the end of the public health emergency and its implications regarding employee benefits. Devin sits around the horn for me here in New York City, and I'm really glad that Devin is back with us. Devin, thank you, and the floor is yours.
Thanks, Gabe. Hello, everybody. So as is sort of I guess you could start the next slide, Kathy, please. So as the heading says, President Biden announced earlier this year the end of the public health emergency, and we'll be discussing the employee benefits implications this afternoon. So I'll start with some background. 3 years ago, almost to the day, on March 13th, 2020, the prior administration announced a COVID national emergency. Taking that into consideration, if you think about where we were globally at the time, there's international panic, fear. A lot of us were very scared. We thought the world was ending. And I guess in response to that, the Department of Labor and Treasury put their heads together and said, well, the world's ending, so I guess we could give people a little bit more time to get their act in order and extend deadlines for various ERISA governed employee benefit plans. And I guess we'll be lenient in that respect. So on May 4th of 2020, the agencies issued a joint notice, the notification of relief, extension of timeframes. And what it did was it extended or told or paused certain timeframes and deadlines that would otherwise be applicable to just generally group health plans, disability and other welfare plans governed by ERISA, and pension plans governed by ERISA. Next slide, please. So under the notice and subsequent clarifying guidance, what was indicated was that administrators of such ERISA governed plans were instructed to toll or disregard or delay the period for certain ERISA governed plans from beginning March 1, 2020 until 60 days after the end of the national emergency. And the 60-day period after the end of the national emergency is called the outbreak period, essentially. So the maximum tolling or disregarded period is limited to the earlier of 1 year or the end of the outbreak period. So just as an example, we'll use COBRA as an example. So COBRA ordinarily requires qualified beneficiaries to make an election for COBRA coverage before the later of 60 days from the loss of coverage or 60 days from the date of the COBRA notice being provided to the qualified beneficiary. Because of these extensions from the IRS and DOL, a qualified beneficiary would have, instead of just the 60 days from the start date, they would have 1 year and 60 days to elect their COBRA coverage. So that's basically how it works. You freeze time, you jump ahead a year, and then the clock starts ticking there. The same principles would apply, not arguably, but the same principles would apply for certain for appeals of pension benefit claims, for example. So again, if you're filing a claim for benefits under a pension or retirement plan, you're denied your claim. Ordinarily, you'd have 60 days. Thanks to the extension, you get 1 year plus 60 days to appeal the denied claim. So next slide, please. So earlier this year on January 30th, this is sort of the big news. January 30th, President Biden announced his intent to end the national emergency effective May 11th, 2023. Now, again, I remind you all that the outbreak period ends 60 days after the end of the national emergency. So the outbreak period will be ending July 10th, 2023. So what that means is that the tolling period, because it's the lesser of 1 year from the start date or the end of the outbreak period, the tolling period or the disregarded period also ends July 10th, 2023. So what this means is, going back to a pension appeal example, if you've got a participant who is denied a claim for benefits, let's say February 1st of this year, rather than be given a year and 60 days to file their appeal, they'll be given 60 days from July 10th of this year to file their appeal under ERISA. Next slide, please. So what does this mean? I think we have to start with the overall guiding principle for ERISA fiduciaries. And this has been reiterated multiple times through the many pieces of guidance that the IRS and DOL have issued relating to this topic. You'd think it'd be simple, but they've had to issue, I think, 3 subsequent notices clarifying the initial notice. But they never hesitate to remind readers that the guiding principle for administering employee benefit plans is to act reasonably, prudently in the interests of workers and their families who rely on their health, retirement, or other benefits governed or protected under ERISA. So what this means is that plan fiduciaries should be making reasonable accommodations to prevent the loss or undue delay in payment of benefits, and should take steps to minimize the chance that individuals will lose benefits due to a failure to comply with a pre-established time frame. So basically, they're admonishing administrators and plan sponsors to essentially have a heart when it comes to some of these things and applying these standards. So with that in mind, and with the impending end of the outbreak period, what should plan sponsors and administrators do to make sure that their plan participants or qualified beneficiaries don't lose out on a benefit? So plan sponsors are advised to coordinate with their administrators to review and revise or otherwise inform affected participants about the new deadline. So if people were under the impression that they had a year and X number of days to file a COBRA election or an appeal, we want to make sure that people are made aware that no, actually you don't have a year anymore. You have until the end of the outbreak period, which is July 10th, plus your 60 days. So just as an example, if you've got letters that you're sending out denying someone, again, going back to the pension example, if you're denying someone their pension claim, we best to advise them in your letter informing them of their rights under ERISA that they have until the end of the outbreak period plus 60 days to file their appeal, or just say, to be more clear and concise, give them the actual date. So for example, again, if someone's claim is being denied before the outbreak period again is July 10th, 2023, 60 days from that for a pension appeal, it would be September 8th, 2023, would be the date they'd have to perfect their appeal. So other similar notices that you'd be informing participants about the rights should keep the new deadline in mind. So that's basically it for the substance of this. And so, yeah, I think that's it for me, Gabe.
Well, thank you so much, Devin. Really appreciate the time and the update. We've gotten a number of questions along the way in the chat about whether New York State COVID sick leave remains in effect. The answer is yes, it does. It takes a legislative act for that to change because it's in statute. Something we're watching closely, and if anything were to change, all of you will be among the first to know, but nothing that I can report out today. And let me now shift to our next speaker, who is with us from Syracuse. She's new to the program. It's Ksenia Primo, and Ksenia will be speaking on immigration issues to keep in mind when contemplating layoffs or reductions in force. A bit about Ksenia to begin. She, as I noted, is based in our Syracuse office and defends clients against employment-related claims in federal and New York State courts, and also before the EEOC, New York State Division of Human Rights, and certainly has an expertise in immigration issues generally. Studied at Syracuse College of Law and at Hamilton College, and we are thrilled to learn from her. So Ksenia, welcome to the program, and the floor is yours.
Thank you, Gabe. Welcome, everybody. I am very thrilled to speak with you today regarding consequences of terminating foreign workers. And I just wanted to begin by saying it's always a very difficult decision to terminate an employee, but it is particularly difficult when it comes to terminating foreign workers. And the reason for that is because it can have very negative consequences on their status in the United States. What makes this area a little bit challenging is that different rules apply to different visa classifications. Because we don't have a lot of time today, I will concentrate on most frequently used work visas and will explain the rules that apply to those visas when the employee is terminated. So let's start with the H-1B work visa. As you may already know, that particular work visa is available to employees in professional positions. And professional position for H-1B purposes is defined as a position that requires at least a bachelor's degree in a specific field of study. And the employee has a bachelor's degree in that field of study, and therefore they qualify for an H-1B visa. When it comes to terminating an H-1B employee, we have to keep a couple of things in mind. when there is an involuntary termination, or even when there is a voluntary termination, right? The employee just resigns because they found another job that they would like to pursue. The best practice is to send a letter to the USCIS, notifying USCIS of the termination of employment. Well, how do you do that? How do you send a letter, right? So what you should do is find the most recent H-1B approval notice for that worker and look at this, and the notice will have a service center indicated on that H-1B approval notice, showing, right, where the petition was previously filed. So you will send a letter to that particular service center attaching the H-1B approval notice and notifying the USCIS that the employment has been terminated. You will insert the effective date of termination, and then you will request that the USCIS negate the petition. So you're basically asking for withdrawal of the H-1B petition that was previously filed on behalf of this particular employee. Another step that you will need to take is to withdraw the labor condition application that was filed with the Department of Labor for that particular petition. And the reason you want to take these steps is to protect yourself from future claims that a terminated employee may potentially assert against the company. There are a lot of cases out there where the employers have not taken these steps, and then the employee sued the employer, saying that they were entitled to the wages during that period of time that they were not working for the employer. And the only thing that the court will look at is whether we had a bona fide termination, and they will be looking for that withdrawal of the LCA and the notification to the USCIS. If we don't have those in our records, there is a pretty good chance that we will be found liable for the wages from the period of time that the H-1B approval notice is valid. So that's the reason we want to do the proper notifications. And one more thing to keep in mind about the H-1B terminations: when you're terminating an H-1B worker and it is an involuntary termination, then you're also responsible for offering to pay for a ticket back home, for the cost of the ticket back home for the employee. You're not responsible for the tickets for the dependents. You're not responsible for transporting the employee's belongings back to the home country, but you are responsible for offering them the cost of return transportation back home. So what we typically do to document this for our files, if we know what the date of termination is going to be, we go on a search engine, Expedia.com or Google Flights or what have you, and we look for tickets, and we see what the average price of a ticket is on that particular day or during that particular week. We print out from the website that data, and we offer the employee that amount to cover the ticket back home. If the termination is voluntary, if they just resign their employment, you don't have to do that. You don't have to pay for the ticket back home. It applies only in involuntary terminations. Now, let's talk a little bit about TN visas and L visas. So TN visas are available to professional workers from Mexico and Canada, and L visas are available to intra-company transferees. So folks that work for multinational companies and a parent is transferring employee to a subsidiary or affiliate, those type of situations. So for employees on those work visas, if you terminated them, you are not responsible for notifying USCIS of the termination. There is no requirement. And similarly, you're not responsible for paying for their ticket back home. So there is a little bit of a difference in the treatment of the employees on H-1B visas and employees on TN and L visas. Another thing to keep in mind, so right, what is this gonna do, right? The termination, how is it going to impact the employee's status in the United States? So employees on H-1Bs, TN, and L visas are typically given a 60-day grace period to find alternative employment in the United States or change their status to another category. And the 60-day period applies only if they have at least, right, that much time remaining on their status. So you may have a situation where a worker is not going to have 60 days of their H-1B petition was expiring sooner than that. But in most cases, people will have at least 60 days to find alternative employment, and for the H-1B workers, if they can find that another employer who can file an H-1B petition for them during that 60-day period, they can stay in the United States and then they continue working in the United States that don't have to go back home. However, if they are not able to secure alternative employment or change status to another category, they will have to go home. And of course, it can have very negative impact on them and their families if this is happening in the middle of the school year, for example, right? Having to take kids out of school and going back home is pretty devastating for many folks. So those are the considerations for when terminating people on work visas and knowing what the consequences are. Another thing that I did want to mention is many of you are familiar with the green card processing for foreign workers. And one of the steps in that green card processing is the approval of the I-140 petition. When the employee is terminated, be careful about the timing of when you withdraw the I-140 petition if you decide to do so. There is no legal requirement to withdraw the I-140 petition that was previously approved for the employee. If you withdraw it before 180 days passed since it was approved, the employee is not going to be able to use any of the benefits that attach to that I-140 approval. And some of those benefits are very significant. Some folks are able to extend the H-1B visas in 3-year increments based on approved I-140 petition beyond the 6-year maximum. So that's a very, very big benefit. And there are a lot of other benefits that attach. I mean, the only thing that I want to highlight for you is if you do have an employee with an approved I-140 petition, you probably don't want to withdraw that until that 180-day period passed from the time of the approval, so the employee can continue receiving benefits under that I-140 approval notice. And the final thing that I will mention is the consequences that a layoff can have on a pending green card process, right? So for example, if you're sponsoring an employee for a green card, as you may already know, you need to conduct a recruitment, right, to show to the government that there are no minimally qualified U.S. workers for the position. When you file the perm application, there is a question on the I-140 application which says, have you had any layoffs within the last 6 months? If you say yes, then that means if you had a layoff and you answer the question yes, then you are under the legal obligation to contact folks that were subject to that layoff that are in the same area of employment, where the foreign national is, and in the same or related occupation, and then you have to evaluate them for that position. So the requirements are pretty strict and they have to be complied with exactly, or the DOL is going to deny your perm application. So in cases like that, if you have a layoff coming or you're in the middle of a layoff and you have green card applications pending, you're about to start them, you do want to talk to your immigration attorney to make sure your timing is right and you're not putting yourself in a predicament when you are, sponsoring employees for green cards. And finally, I would like to mention that right now, we are in a very important period of time. The H-1B registration period started on March 1st, and it will go through March 17th. It will close on March 17th at noon. So if you have any employees or any prospective employees who require H-1B visas, now is the time to contact your immigration attorney. And of course, we are happy to help you with any immigration filings that you may have. Gabe, that's all I've got.
Ksenia, that was plenty, and we really thank you for it. Very informative, and we're grateful that you are here with us today, and we look forward to having you back on the program whenever you have new information to share with the audience. There is a question in the chat that I just wanted to draw your attention to, if you wouldn't mind responding offline. But let me turn to our final speaker who is with us today, and an esteemed speaker at that. It's Peter Robb, who was previous to joining Bond, the general counsel of the National Labor Relations Board, as appointed by President Trump. And Peter is here to discuss how employers, should be approaching severance packages. Peter, of course, comes with a very steeped understanding of those questions and others, and we're delighted that Peter can be on the program for the first time. We hope not the last. Peter, welcome, and the floor is yours.
Thank you very much, Gabe. Well, recently, on February 21st of 2023, the board majority, who now have been all appointed by President Biden, issued a decision at 372 NLRB number 58, McLaren-Macomb. McLaren-Macomb is a hospital in Michigan with about 2,300 employees. And OPIU represents about 350 of them in a service unit. On March 20th, in March 2020, excuse me, the government issued some regulations pursuant to the COVID pandemic, and they prohibited hospitals such as McLaren-Macomb from performing elective surgery or outpatient procedures. As a result, the hospital terminated its outpatient procedures and laid off 11 of the bargaining unit employees. A few months later, in June, the hospital decided that they would permanently close their outpatient units and permanently lay off the 11 employees. Those employees were offered a severance package in varying amounts of money. The severance agreement contained a couple of provisions that the board focused on. The first was a confidentiality provision that required the employee to keep confidential the terms of the severance agreement. The second one that the board focused on was in a clause called non-disclosure, and it contained a requirement that the employee refrain from disparaging the hospital or any of its affiliates indefinitely into the future. Both of those provisions are fairly common provisions. You could probably find them online if your employer has settled employment claims. Probably some form of those were used. Previously, under Trump appointees, which generally is referred to as the Trump board, the board had found that such provisions were not unlawful, and it wasn't unlawful to offer them to employees. The current majority disagreed. They held that the mere proffer of such provisions was unlawful because it interfered with Section 7 rights. The analysis was extremely broad, which is similar to the analyses that this current board majority has used in other contexts. And that is basically, if there's any interference in Section 7 rights, which protect employees' rights to engage in protected concerted activity, dealing with wages, hours, and terms and conditions of employment, that would be unlawful. Previous cases had typically done a balancing test of the employee's Section 7 rights against the employer's inherent rights to run a business. That balancing test is not being used particularly by this current board. The board only talked of one area where it might view an exception, and that is if the provisions were narrowly tailored to waive only the claims, employment claims that the employee would have prior to separation. Obviously, there's some other possibilities here. One of the interesting parts of this case is that the non-disclosure provision also contained a paragraph that prohibited the employee from revealing information of a confidential, privileged, or proprietary nature. The board did not address that at all, one way or the other. Finally, the board also found that the employer had failed to bargain over the decision to make the layoffs permanent and bypassed the union by dealing directly with employees in offering the severance agreements. So this case obviously has substantial impact on severance agreements, as well as any agreement that purports to release the employer from employment claims, etc. There was no statute of limitations issue in this particular case because the charge was filed quickly after the action was taken. The NLRA, National Labor Relations Act, has a 6-month statute of limitations. It's relatively short. So those severance agreements, et cetera, that were in existence more than 6 months ago probably can't be attacked based on the face of the language or the fact that it was proffered to employees. However, if those are going to be enforced from now forward, they need to be assessed to see what the impact of this case is. All of the severance agreements and settlement agreements in employment cases going forward should be reviewed. There is a potential to try to carve out some of these rights under the National Labor Relations Act, but that will depend on what the specific goals are and the tolerance of risk in any given case. At minimum, I would say, though, that future such provisions need to be reviewed. And then, of course, going forward, at least there should be notification if there's a collective bargaining representative union representing the employees, and that notification should be to the decision and to the fact that severance agreements are going to be offered. The exact extent of any bargaining obligation would have to be reviewed under the facts and circumstances of each case. So that's what I have on the board's new decision in McLaren-McComb.
Peter, thank you very much for coming with that analysis to this audience. It's a pleasure to learn from you. And we have gotten through our programming for this afternoon. Any question, by the way, concerning what Peter presented is one that you please should direct to Peter offline. Kathy, if you'd advance to the next slide, please. Let me just provide everybody with the email addresses of today's presenters, myself included. And if you have any query that you'd like to pose, please reach out directly, or of course to the bond attorney with whom you have the closest working relationship. We are very much excited to be back with you next Tuesday. Adam will be hosting at that point, and then I will be with you on the 21st again. In the meanwhile, enjoy this crossover into spring, and wishing all of you a really terrific afternoon and week ahead. Be well.